Dear friends, September 15 every year celebrates by the UNESCO as an International Day of Democracy. Under Article 19 of the Universal Declaration of Human Rights, it was clearly held that everyone has the right of opinion and expression, and the same spirit of article has been enshrined in the Indian Constitution under Article 19. The point herein is that in the International Day for Democracy, it is rightly opt on the part of the central government to delete or defer the sedition law in toto in the statute book of Indian law. Sedition is an offense against the state, and it is considered as a crime in the Indian Penal Code under section 124A. The fact of the matter is that during pre-independent era, the greatest political personalities Bala Gangadhara Tilak, Jawaharlal Nehru, Mahatma Gandhi and Bhagat Singh have been put behind bars under the Sedition Act 124A. After Indian independence in the Constituent Assembly, K.M. Munshi has moved a resolution, a proposal to drop sedition law from the Constitution of India. The point herein is that the Supreme Court of India in Kedarnath versus State of Bihar in the year 1962, it has held that section 124A will be applied only if it leads to or likely to lead to public order or violence. It was accepted constitutionally sedition law, but it is subject to incitement of violence or public order, and thereby the freedom of speech and expression of the citizens of the country have been upheld by the apex court of the land, that is way back in 1962. And in the year 2022, the three members bench of the Supreme Court of India, the top court has held that new cases and pending trials, proceedings and appeals are suspended till the central government enacts a new law under section 124A. The intention of the Supreme Court of India is that the citizens of the country are the conscience keepers of the government in any democratic nation. Hence, they cannot be put behind bars simply because they choose to disagree with the state's policies. This has been the settled position of the Supreme Court of India in 2022. On the other hand, the government of India has made a new Indian Penal Code bill and introduced in the Parliament and passed in both the houses, and it has been sent to the Parliamentary Select Committee. In any point of time, it will be made as a law. The point here is that as per the guidelines given by the Supreme Court of India, it has not acted upon. Only it wants to retain a sedition law under the point of sovereignty, unity and integrity of the nation shall be preserved, and the government of India is not prepared to adhere to the guidelines issued by the Supreme Court of India in 2022. Hence, there is a struggle in between the present central dispensation and the Supreme Court of India, it is not going to be debated right now, but the Supreme Court of India, on hearing all these developments that the bill has been introduced in the recent parliament, it has decided to shift the matter to a 5 members constitutional bench of the Supreme Court to decide the matter as a final say. The point herein is that the Supreme Court of India has held that the provisions, whatever may be brought by the government of India after new legislation, it must be held as a prospective only, not retrospectively. This was the statement and a settled position of the Supreme Court of India. Whether the government of India is going to adhere to the guidelines given by the Supreme Court of India or not, it is yet to be known. The point here is that at least in the International Day of Democracy, at least the government of India shall adhere to the democratic norms, values and ethos that have been enshrined in the Indian Constitution and forefathers of the Indian Constitution, and also the Universal Declaration of Human Rights. This is the message of our video. Thank you so much.